Hello friends, in the series on the income tax cases, today we will discuss a issue which is based on the permanent establishment. In the present case, the issue before the tribunal was that if the assessee is providing a computer reservation system to various travel agencies and if the assessee is not providing any infrastructure to the different travel agents or any financing to the different travel agents to purchase the computers or the system to log in into the website of the assessee, then whether only providing the computer reservation system for booking the various tickets for the airlines and for the accommodation of the hotels, it can be said that whether the assessee have any permanent establishment. This issue has been taken by the Tribunal D bench in the case of Sabre, GLBL Inc. versus Assistant Commissioner of Income Tax, and this case has been reported in 111 ITR Tribunal at page number 446, and the date of the order is 9th February 2024. Friends, in the present case, the assessee is incorporated in USA and the assessee is a tax resident of USA. The assessee is in the business of facilitating booking of airlines and hotel reservations on behalf of the participating airlines and hotels through its computer reservation system by having travel agencies as its end users. From the facts of the case, it was very clear that there was no place of business in India or the assessee was not having any employees in India. But when the assessment proceedings were going on, the learned assessing officer made a view that the assessee have any permanent establishment, and that view was based only on the basis of surmises and conjectures, and the assessing officer alleged that the assessee has attributed the total profits earned from bookings originating in India, and the assessing officer take this approach to tax the profits earned from bookings originating in India. The assessee raised the objections before the DRP, but the DRP, by following a very mundane approach and held the additions which has been suggested by the assessing officer. When this matter came before the tribunal said that in the present case, the revenue is relying on the case of GLBL, which is a very famous case. But the tribunal said that in the present case, the reliance of the revenue on the case of GLBL is misplaced. The tribunal said that in the present case, the assessee has not provided any computer system or any computer infrastructure to the various travel agencies. The assessee has not provided any printer, or the assessee has not provided any softwares which are required to do the reservation, and even the assessee is not providing any financing to build the infrastructure to the various travel agencies. So, in the case, it cannot be said that the assessee do have any permanent establishment or any agency permanent establishment which is existence in India on behalf of the assessee. Friends, in the present case, the facts of the case in the nutshell is that the assessee was only providing a computer reservation system to the various travel agents, and through that computer reservation system, various travel agents were doing the bookings for the various customers, and the assessee do not have any permanent establishment in India, even in the remote senses. But the assessing officer and the DRP took a very narrow approach and alleged that the assessee was having a permanent establishment, So whatever the upward additions were done by the assessing officer and which were stamped by the DRP were deleted by the tribunal. At the end of this video, once again I am repeating the name of the case. The name of the case is Sabre GLBL Inc. versus Assistant Commissioner of Income Tax, and this case has been reported in 111 ITR Tribunal at page number 446. The matter has been decided by Delhi ITAT D bench and the date of the judgment is 9th February 2024. Thank you friends.